This is Paul. I'm just wondering this necessary provision in pleadings relating to supplementary proceedings with show cause hearing and contempt. Yes. There is the following words in capital letters. Your failure to appear as above set forth at the time, date, and place thereof will cause the court to issue a bench warrant for your apprehension and confinement in jail until such time as the matter can be heard until bail is posted. Now, no bench warrant will be issued in such cases for the apprehension of the cited person if such language has been amended, which orders to show cause for contempt will be served on the alleged contempt nor in the manner of service of a summons and complaint. Yeah. Now, we had a show cause hearing where I was not given any notice that if I didn't appear that you could issue. Well, it was here, just a second. Child support worksheet, Commissioner Knieves, yes. Declaration, so on and so forth, so on and so forth. It was part, maybe it's in this one, hang on. Sheriff's, oh, right here, or show cause, on 7/19 of 2013, yes. When you had that, I never read this capitalization letters for a show cause hearing. Was that a show cause hearing for contempt of court, or was it you wanted me to show the cause why I wasn't appearing in court? Now, when you put it down on the docket, yes, can you actually have a court hearing without notice being given to the respondent that that's what it says? Are you going to arrest me for contempt of court for a hearing that I missed on August 30th of 2013 because I didn't appear in court for the permanent protection order hearing, the same hearing that the sheriff served me? Now, if you have a show cause hearing, and a show cause hearing requires a certain language in the notice and summons, show cause for contempt should be served alleged contempt nor. And I don't actually get that. Were you trying to arrest me for not appearing in court when not giving me the actual notice of the court hearing, or at least the notice of the court hearing for the show cause hearing? Yes. Now, orders for the protection of a child, yes. Notices filed someplace. The date of birth may include general authority. Trial setting, counsel shall note on the trial forms all the contested motion contingencies. A party of counsel filing motion affidavit shall comply with. Now, jury instructions. Hang on just a second here. Filing motion affidavit, notice to court of calendar and jury trial. Whenever a case has been set for trial thereafter, settled will not be tried for any reason. Juries thereafter waived. Did any jurors get notice of the actual jury trial, my speedy trial that I didn't waive, that Bruce Hannafy said that I did? And I just wanted to know, you didn't actually expect to have a jury trial because I wasn't in Sequim, Washington, was I? See, see, your whole thought was, well, we'll get him for failure to appear to a mental health evaluation. Then my public defender that was paid decided to mention it to the judge one day during the court hearing. He did. Judge said, well, get that fucker in here right now, okay? We'll schedule a hearing for the next Monday. And then instead of having the court hearing on the 27th and explaining why it was they didn't reschedule a mental health evaluation for myself, you decided that you would make note of it during the actual trials of other individuals. Yes, bringing it to the attention of Judge Porter. Now, since I wasn't on the docket at any time before the September 27th of 2016, why was my name mentioned in any court hearing or any court setting without me being present at the time? Now, let's say my public defender, or maybe Mr. Nichols, did he want to know, or did Mr. Budnick go to his mental health evaluation? You were having some sort of private conversation about my personal case without me being there. Now, as I look at it, during the arraignment, there was no mention of mental illness. No, there wasn't. There was the allegation I was in Sequim, Washington, yes, on January 4th, but I wasn't. And there was nothing said to me about me being mentally ill the 5th day of January of 2016. Yes. There was nothing about hold until the court reviews a mental health evaluation. Yes. I was allowed to leave on personal recognizance. Yes, he was. Yes, he was. And then we had another court hearing on the 8th of March of 2016. Yes. We were going to go to trial. Yes. But it doesn't say anything about hold until the court reviews a mental health evaluation. Says I shall defend. I appeared in court on the 15th of March 2016 at 9 a.m. And then when I was arraigned, right, the trial date was set for the March 2nd of 2016. Yeah, but there was nothing about a mental health evaluation. But then Bruce Hanafy, my public defender, said, well, my client waived his right to a speedy trial. When I didn't, I actually documented I wanted him to explain his understanding of a speedy trial. And on the 15th day of March of 2016, you put on the wrong form, because it wasn't 57 days from arraignment, that we were going to trial on April 27th of 2016. Yes. Now, I wanted to have the actual jury trial on April 4th of 2016, 90 days from arraignment, because I was on the bus that morning and I was in this library that afternoon. But for some reason, somebody decided we're going to have a mental health evaluation, and we're going to prove Paul, as a homeless man, is mentally ill or mentally defective. Pooch, 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 pooch. Then, when you decided that you wouldn't reschedule the mental health evaluation, yes, you decided to bring my name up when I wasn't present in court. Yes. How can a public defender talk about his client without his client being there? I would think that as the individual that's accused of the crime, that I would have to be present at any time that the public defender talks about me. And we could have had it on the 27th, where I would have been there, and the public defender would have said, well, Mr. Budnick had a blood nausea on the 6th of September, and he'd called our office at 5:30 a.m. from the homeless shelter he was staying at. But somebody decided to mention my... What the fuck did you do? Hearing of motion calendar. How do you talk about other cases without the actual defendant present at the time of the discussion?